Solving Indian Patent Agent Exam May 2022, Paper 1 Part A. Please note that all the information provided in this video is based on the Patents Act of 1970 and the Patents Rules of 2003, as updated or amended until April 2023 when this video was created. It is recommended that you verify the latest information on amendments to the Patent Act and Patent Rules from April 2023 onwards while watching this video. We have put in a great deal of care and effort into creating this video by referring to the Patents Act of 1970 and the Patents Rules of 2003, as updated or amended until April 2023. We have also reviewed the content with experts in this field multiple times. However, there is still a possibility of typos or ambiguity in some answers. We kindly request you to leave a comment under the video with the correct information and reference links if you notice any mistakes. The Indian Patent Agent exam consists of two papers, Paper 1 and Paper 2. Paper 1 consists of 3 parts: Part A, 60 marks, Part B, 10 marks, and Part C, 30 marks. There is no negative marking. Candidates have 2 hours to complete this paper. Part A is of 60 marks and consists of 30 multiple-choice questions with one option correct of 2 marks each. In this video, we'll be providing solutions to Paper 1, Part A.
Question 1. Nile Incorporated is a global e-commerce major with operations in multiple countries. Nile had filed a patent application in Korea on the 1st of June 2020. Subsequently, Nile filed a patent application for the same invention in Canada on the 1st of May 2021, claiming priority of the Korean application. Finally, Nile made a convention application in India on the 1st of November 2021, claiming priority of the Canadian application. The Korean application was published on the 2nd of December 2021. Which of the following statement is true? A. Nile is entitled to claim the priority of THC Canadian application. The claims of the Indian application are not anticipated by publication of Korean application. B. Nile is entitled to claim the priority of the Canadian application. The claims of the Indian application are anticipated by publication of Korean application. C. Nile is not entitled to claim the priority of the Canadian application. The claims of the Indian application are not anticipated by the publication of Korean application. D. Nile is not entitled to claim the priority of the Canadian application. The claims of the Indian application are anticipated by the publication of Korean application.
The correct answer to question 1 is option C. Nile is not entitled to claim the priority of the Canadian application. The claims of the Indian application are not anticipated by the publication of Korean application. Explanation. According to Section 135 of the Indian Patents Act, an applicant can claim priority from an earlier filed application in a convention country within 12 months for patents. In this case, Nile filed a patent application in Canada within 12 months of filing in Korea. However, Nile filed a convention application in India more than 12 months after filing in Korea and therefore cannot claim priority from the Korean application. Instead, Nile is claiming priority from the Canadian application, which is not valid because priority can only be claimed from the first filed application in a convention country. The publication of the Korean application on the 2nd of December 2021 would not anticipate the claims of the Indian application because the Indian application was filed before the publication date.
Question 2. Your client, IP India Incorporated, wishes to file a PCT application claiming priority from an application that they are going to make in India. If they wishes to utilize the time limits available under PCT to the fullest extent, how will you organize the following items related to his PCT application in most likely chronological order? 1. Filing of PCT international application. 2. Filing of priority application in India. 3. PCT international publication. 4. Grant of patent in a designated country. 5. PCT national phase entry in designated county. A. 2, 5, 1, 3, 4, B, 2, 1, 3, 5, 4, C, 1, 2, 3, 4, 5, D, 2, 1, 5, 3, 4. The correct answer to question 2 is option B, 2, 1, 3, 5, 4. Explanation. The most likely chronological order of events for filing a PCET application claiming priority from an application filed in India would be 1. Filing of the priority application in India. 2. Filing of the PCET international application within 12 months of the priority date. 3. PCET international publication 18 months after the priority date. 4. PCET national phase entry in designated countries within 30 or 31 months, depending on the country, from the priority date. 5. Grant of patent in a designated country after examination and allowance of the national phase application. Question 3. Which of the following is not a ground of pre-grant opposition under Section 25? 1. A. That applicant has failed to disclose to the controller the information required by Section 8. B. That the subject of any claim of the complete specification is not an invention. C. That the claims of the complete specification is not clear. D. That the invention so far as claimed in any claim of the complete specification is anticipated.
The correct answer to question 3 is option C. That the claims of the complete specification is not clear. Explanation. According to Section 25(1) of the Indian Patents Act, a pre-grant opposition can be filed on several grounds including A. That the applicant has failed to disclose to the controller the information required by Section 8. B. That the subject of any claim of the complete specification is not an invention. D. That the invention so far as claimed in any claim of the complete specification is anticipated. However, option C, lack of clarity in the claims of the complete specification, is not a ground for pre-grant opposition under Section 25(1).
Question 4. Which of the following is not a requirement of the complete specification under Section 10 of the Act? A. Fully and particularly describe the invention and its operation or use and the method by which it is to be performed. B. End with a claim or claims defining the scope of the invention for which protection is claimed. C. A declaration by inventors that the information given in the specification is true to their knowledge. D. None of the above.
The correct answer to question 4 is option C, a declaration by inventors that the information given in the specification is true to their knowledge. Explanation. According to Section 10 of the Indian Patents Act, a complete specification must A. Fully and particularly describe the invention and its operation or use and the method by which it is to be performed. B. End with a claim or claims defining the scope of the invention for which protection is claimed. However, a declaration by inventors that the information given in the specification is true to their knowledge is not a requirement of the complete specification under Section 10 of the Act.
Question 5. An application for restoration of a lapsed patent may be filed within from the date on which the patent ceased to have effect. A. 18 months. B. 12 months. C. 6 months. D. 9 months.
The correct answer to question 5 is option A, 18 months. Explanation. According to Section 60 of the Indian Patents Act, an application for restoration of a lapsed patent may be filed within 18 months from the date on which the patent ceased to have effect. The application must be accompanied by a statement setting out the circumstances that led to the failure to pay the renewal fee and must be made in the prescribed manner.
Question 6. Which section of Patents Act empowers central government to revoke a patent in public interest? Options: A. 25, B. 57, C. 66, D. 84.
The correct answer to question 6 is option C, 66. Explanation. According to Section 66 of the Indian Patents Act, the central government has the power to revoke a patent in public interest. If the central government is of the opinion that a patent or the mode in which it is exercised is mischievous to the state or generally prejudicial to the public, it may, after giving the patentee an opportunity to be heard, make a declaration to that effect in the official gazette, and thereupon the patent shall be deemed to be revoked.
Question 7. Patent Office is established under which section of the Act? Options: A. 1, B. 3, C. 138, D. 74.
The correct answer to question 7 is option D. 74. Explanation. According to Section 74 of the Indian Patents Act, the Patent Office is established by the central government for the purpose of granting patents and for discharging other functions conferred on it by or under the Act. The head office of the Patent Office is located in Kolkata and branch offices are located in Mumbai, Delhi, and Chennai.
Question 8. Which of the following is not a ground for making an application for compulsory license? Options: A. The reasonable requirements of the public with respect to the patented invention have not been satisfied. B. The patentee is a company which has gone bankrupt. C. The patented invention is not available to the public at a reasonably affordable price. D. The patented invention is not worked in the territory of India. The correct answer to question 8 is option B. The patentee is a company which has gone bankrupt. Explanation. According to Section 84 of the Indian Patents Act, an application for a compulsory license can be made on several grounds including: A. That the reasonable requirements of the public with respect to the patented invention have not been satisfied. C. That the patented invention is not available to the public at a reasonably affordable price. D. That the patented invention is not worked in the territory of India. However, the fact that the patentee is a company which has gone bankrupt is not a ground for making an application for a compulsory license. Question 9. Which of the following could be minimum fees to be paid for an application for patent filed by an educational institution as on March 2022? Options: A. 1,000, B. 1,600, C. 4,000, D. 8,000. The correct answer to question 9 is B. 1,600. Explanation. As per the Patents Amendment Rules 2021, which came into effect on 21st of September 2021, benefits related to 80% reduced fee for patent filing and prosecution have been extended to educational institutions as well. This means that the minimum fees to be paid for an application for a patent filed by an educational institution as on April 2023 would be 1/5 of the current official fee and equal to that payable by a natural person/startup/small entity. The current official fee for a natural person/startup/small entity for e-filing a patent application is INR, Indian rupees, 1,600. So the minimum fees to be paid by an educational institution would be INR, Indian rupees, 1,600. Note: as of April 2023, physical filing of patent application minimum fee is INR, Indian rupees, 1,700. Question 10. Prarthi is an inventor for an application for patent filed by a university. If her name has to appear in the patent certificate, a request has to be made in underscore. Options: A. Form 7, B. Form 15, C. Form 8, D. Form 11. The correct answer to question 10 is option C. Form 8. Explanation. If Prarthi is an inventor for an application for a patent filed by a university and her name has to appear in the patent certificate, a request has to be made in Form 8. Form 8 is the request or claim regarding mention of inventor as such in a patent form. This form is used to request that the name of the inventor be mentioned in the patent certificate. Question 11. Ms. Lakshmi Priya wishes to file a patent application in India, but she came to know some of the inventions are not patentable in accordance with Indian Patents Act. Could you please help her to match list 1 with list 2 and select correct code? List 1. 1. Section 3L. 2. Section 3M. 3. Section 3N. 4. Section 3O. List 2. A. Presentation of an information. B. Topography of integrated circuits. C. Method of performing mental act. D. Television productions. Codes. A. 1D, 2C, 3A, 4B, B. 1A, 2B, 3C, 4D, C. 1C, 2A, 3B, 4D, D. 1B, 2C, 3D, 4A. The correct code to question 11 for matching list 1 with list 2 is option A. 1D, 2C, 3A, 4B. Explanation. According to the Indian Patents Act, Section 3L states that a literary, dramatic, musical or artistic work or any other aesthetic creation whatsoever including cinematographic works and television productions is not patentable. Section 3M states that a mere scheme or rule or method of performing mental act or method of playing game is not patentable. Section 3N states that a presentation of information is not patentable. Section 3O states that topography of integrated circuits is not patentable. 12. Time limit under Rule 132, within which an application for selling aside an ex parte order passed by the controller shall be from the date of communication of the order. Options: A. 1 month, B. 4 months, C. 3 months, D. None of the above.
The correct answer to question 12 is option A. 1 month. Explanation. According to Rule 132 of the Indian Patents Act, an application to the controller for setting aside an ex parte order passed by him shall be made in Form 24 within 1 month from the date of communication of such order to the applicant or within such further period not exceeding 1 month as the controller may allow on a request made.
Question 13. Anthony owns a small workshop in Mangalore. He has invented a new coconut grater. He has filed a provisional specification on the 1st of June 2021. As the time limit for filing complete specification is only a fortnight away, Anthony realizes that he needs 4 more months to complete his invention and file a complete specification. Which of the following is appropriate, as per statute? Advice to Anthony. Options: A. The time limit for filing complete specification can be extended by 4 months by filing Form 4. B. Anthony can file the complete specification after 4 months along with a request to post dating of the application by 4 months. C. Anthony can allow this application to be abandoned by not filing complete specification and file new application after 4 months with complete specification. D. Anthony can file a request for post-dating the current application by 4 months immediately and file complete specification within 4 months.
The correct answer to question 13 is to advise Anthony with option D. Anthony can file a request for post-dating the current application by 4 months immediately and file complete specification within 4 months. Explanation. According to Section 9(4) of the Indian Patents Act, if a complete specification has been filed in pursuance of an application for a patent accompanied by a provisional specification or by a specification treated by virtue of a direction under subsection 3 as a provisional specification, the controller may, if the applicant so requests at any time before grant of patent, cancel the provisional specification and post-date the application to the date of filing of the complete specification.
Question 14. COVID Med Limited wants to manufacture an anti-malaria drug in India solely for exporting to an island nation. Acacia, a Swedish MNC, holds the patent for the drug in India. Which of the following is not a requirement to be met by COVID Med for obtaining a compulsory license for the export of the drug to the island nation? Options: A. That COVID Med has obtained a compulsory license for the drug in the island nation or by notification allowed the import. B. That COVID Med has obtained a compulsory license in India under Section 84. E. That the island nation do not have sufficient manufacturing facility in pharmaceutical sector. D. That the island nation is using the importation of the drug for addressing their public health problems.
The correct answer to question 14 is option B. That COVID Med has obtained a compulsory license in India under Section 84. Explanation. According to Section 92 of the Indian Patents Act, a compulsory license can be granted for the manufacture and export of patented pharmaceutical products to any country having insufficient or no manufacturing capacity in the pharmaceutical sector for the concerned product to address public health problems. Based on this information, it appears that Option A is a requirement for obtaining a compulsory license for the export of the drug to the island nation. COVID-Med must have obtained a compulsory license for the drug in the island nation or by notification allowed the import. Option C is also a requirement. The island nation must not have sufficient manufacturing facility in the pharmaceutical sector. Option D is also a requirement. The island nation must be using the importation of the drug for addressing their public health problems. Option B, that COVID-Med has obtained a compulsory license in India under Section 84, is not a requirement for obtaining a compulsory license for the export of the drug to the island nation.
Question 15. A Danish citizen who is residing in India wishes to file first application at Denmark. Weather options: A. He has to take permission from Patent Office India before filing in Denmark. B. He has to take permission from Danish Patent Office before filing in Denmark. C. He has to take permission from Denmark Embassy in India before filing in Denmark. D. He has to take permission from Indian Embassy in Denmark before filing in Denmark.
The correct answer to question 15 is option A. He has to take permission from Patent Office India before filing in Denmark. Explanation: according to Section 39 of the Indian Patents Act, a person resident in India is required to obtain a written permit from the Indian Patent Office before making or causing to be made any application outside India for the grant of a patent for an invention. Based on this information, Option A is correct. The Danish citizen who is residing in India must take permission from the Indian Patent Office before filing a patent application in Denmark. Option B is not correct. The Danish citizen does not need to take permission from the Danish Patent Office before filing in Denmark. Option C is not correct. The Danish citizen does not need to take permission from the Denmark Embassy in India before filing in Denmark. Option D is not correct. The Danish citizen does not need to take permission from the Indian Embassy in Denmark before filing in Denmark. Therefore, the correct answer is option A. He has to take permission from the Indian Patent Office before filing in Denmark.
Question 16. Arrange the following items related to post-grant opposition in the most likely chronological order. 1. Revocation of patent. 2. Opposition board formation. 3. Filing of post-grant opposition. 4. Grant of patent options: A. 1, 3, 4, 2. B. 1, 2, 3, 4. C. 4, 3, 2, 1. D. 1, 4, 2, 3.
The correct answer to question 16 is option C. 4, 3, 2, 1. Explanation: the most likely chronological order of the items related to post-grant opposition would be: first, the grant of patent; 4. Second, the filing of post-grant opposition; 3. Third, the formation of an opposition board; 2. And finally, the revocation of patent; 1. If the opposition is successful. Therefore, the correct answer is option C. 4, 3, 2, 1.
Question 17. Mr. Devam would like to know times limits generally available to meet requirements in accordance with the patents law. Match list 1 and list 2 and select correct answers. List 1. 1. Information and undertaking under Section 8(1). 2. Reply to first examination report with extension. 3. PCT National Phase Entry to India. 4. Request for examination. List 2. A. Within 31 months. B. Within 48 months. C. Within 6 months. D. Within 9 months. Codes: A. 1A, 2B, 3C, 4D, B. 1C, 2D, 3A, 4B, C. 1B, 2C, 3D, 4A, D. 1D, 2A, 3B, 4C.
The correct code to question 17 for matching list 1 with list 2 is option B, 1C, 2D, 3A, 4B. This means that the time limit for filing information and undertaking under Section 8(1) is within 6 months. C. The time limit for applying to a first examination report with an extension is within 9 months. D. The time limit for PCT national phase entry to India is within 31 months. A. And the time limit for filing a request for examination is within 48 months. B. Explanation. According to Section 8(1) of the Indian Patents Act and Rule 12 of Indian Patent Rules, an applicant for a patent must file a statement setting out detailed particulars of any application for a patent filed outside India in respect of the same or substantially the same invention within 6 months from the date of filing in India. Therefore, the time limit for filing information and undertaking under Section 8(1) is within 6 months. C. The time limit for applying to a first examination report is 6 months with an extension of 3 months upon request. So, the time limit for applying to a first examination report with an extension is within 9 months. D. According to Rule 24 of Indian Patent Rules, the time limit for entering the national phase of a PCT application in India is 31 months from the date of priority. Therefore, the time limit for PCT national phase entry to India is within 31 months. A. According to Section 11B of the Indian Patents Act and Rule 24B, 1(I) of Indian Patent Rules, a request for examination of a patent application in India must be made within 48 months from the date of priority. Therefore, the time limit for filing a request for examination is within 48 months. B.
Question 18. Minimum age limit for a person to be mentioned as inventor in a patent application shall be options A. 18 years, B. 21 years, C. 14 years, D. None of the above.
The correct answer to question 18 is option D. None of the above. Explanation. There is no age restriction for a person to be mentioned as an inventor in a patent application in India.
Question 19. Controller has which one of the following powers of a civil court? Options A. Issue an order to arrest a person in case of infringement with the help of police. B. Order of imprisonment to the defaulter. C. Examine a person on oath and take evidence on oath. D. None of the above.
The correct answer to question 19 is option C. Examine a person on oath and take evidence on oath. Explanation. The controller has certain powers of a civil court for the purpose of receiving evidence, administering oaths, enforcing the attendance of witnesses, and issuing permissions for the examination of witnesses. According to Section 77 of the Patents Act, 1970, the controller has powers of a civil court while trying a suit under Code of Civil Procedure, 1908 in respect of summoning and enforcing the attendance of any person and examining him on oath. So the correct answer to question 19 is option C.
Question 20. Which of the following time limits can he extended by the controller on a petition filed under Rule 138? Options A. Time limit for putting the application in order for grant. B. Time limit for filing the request for examination. C. Time limit for paying national phase application in India. D. Time limit for furnishing proof of right.
The correct answer to question 20 is D. Time limit for furnishing proof of right. Explanation. According to Rule 138 of the Patents Rules, 2003, the time prescribed by these rules for doing any act or taking any proceeding may be extended by the controller for a period of 1 month if he thinks it fit to do so and upon such terms as he may direct. However, this rule does not apply to the time prescribed in Clause I of Sub-Rule 4 of Rule 20, Sub-Rule 6 of Rule 20, Rule 21, Sub-Rules 1, 5, and 6 of Rule 24B, Sub-Rules 10 and 11 of Rule 24C, Sub-Rule 4 of Rule 55, Sub-Rule 1A of Rule 80 and Sub-Rules 1 and 2 of Rule 130.
Question 21. Radhamani, an IPR student, wishes to know the important case laws on various provisions related to patent in India. Match list 1 and list 2 and select correct code. List 1. 1. Compulsory license. 2. Section 3D. 3. Date of grant of patent. 4. Infringement. List 2. A. Novartis Act vs Union of India. B. Bayers Corporation vs Natco Pharma. C. Bajaj Auto Limited vs TVS Motor Company. D. Dr. Snehlata C. Gupta vs Union of India. Codes: A. 1A, 2B, 3C, 4D. B. 1B, 2A, 3D, 4C. C. 1D, 2A, 3B, 4B. D. 1C, 2D, 3B, 4A.
The correct answer to question 21 is option B. 1B, 2A, 3D, 4C will be the correct code for matching list 1 with list 2. Explanation: the correct match between list 1 and list 2 would be 1. Compulsory license, B. Bayers Corporation vs Natco Pharma 2. Section 3D, A. Novartis Ag vs Union of India 3. Date of grant of patent, D. Dr. Snehlata C. Gupta vs Union of India 4. Infringement, C. Bajaj Auto Limited vs TVS Motor Company.
Question 22. Assertion: A. Patent right is a negative right. Reason: R. Patentee has exclusive right to prevent third parties, who do not have his consent, from using his invention. Codes: A. Both A and R are true, and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. D. A is false, but R is true.
The correct answer to question 22 is option A. Both A and R are true, and R is the correct explanation of A. Explanation: a patent right is indeed a negative right, as it gives the patentee the exclusive right to prevent others from making, using, selling, or importing the patented invention without their consent. So assertion A is true. Reason: R is also true and correctly explains why a patent right is a negative right. The patentee has the exclusive right to prevent third parties from using their invention without their consent.
Question 23. Arrange the following items related to pre-grant opposition procedure. Section 25(1), under Patents Act in the most likely chronological order. 1. Filing of pre-grant opposition by way of representation. 2. Publication of patent application. 3. Applicant filing reply to the pre-grant representation. 4. Hearing before the controller. Options: A. 1, 2, 3, 4. B. 2, 1, 3, 4. C. 4, 3, 1, 2. D. 2, 3, 4, 1.
The correct answer to question 23 is option B. 2, 1, 3, 4. Explanation: the most likely chronological order of the items related to pre-grant opposition procedure, Section 25(1), under the Patents Act would be 1. Publication of patent application. 2. Filing of pre-grant opposition by way of representation. 3. Applicant filing reply to the pre-grant representation. 4. Hearing before the controller.
Question 24. Mr. Akhil has already filed his patent application, but he is confused with the applicability of the forms provided. Could you please help him to match list 1 with list 2 and select correct code? List 1. 1. Request for publication. 2. Request for expedited examination. 3. Application for amendment of the application for patent. 4. Request regarding change in applicant for patent. List 2. A. Form 6. B. Form 13. C. Form 9. D. Form 18A. Codes: Option A. 1A, 2B, 3C, 4D. Option B. 1C, 2D, 3B, 4A. Option C. 1D, 2B, 3A, 4C. Option D 1B2C3D4A.
The correct code to question 24 for matching list 1 with list 2 is option B 1C2D3B4A. Explanation. The correct match between list 1 and list 2 would be 1. Request for publication, C. Form 9(2), request for expedited examination, D. Form 18A3, application for amendment of the application for patent, B. Form 13(4), request regarding change in applicant for patent, A. Form 6.
Question 25. Assertion A. Applicant does not have unconditional freedom to file a divisional application. Reason R. A divisional application can be filed by applicant only when there is more than one invention in the specification. Options A. Both A and R are true, and R is a correct explanation for A. B. Both A and R are true, and R is not the correct explanation for A. C. A is true, but R is false. D. A is false, but R is false.
The correct answer to question 25 is option A. Both A and R are true, and R is a correct explanation for A. Explanation. Assertion A is true. An applicant does not have unconditional freedom to file a divisional application. A divisional application can only be filed when certain conditions are met. Reason R is also true. One of the conditions for filing a divisional application is that there must be more than one invention disclosed in the specification of the parent application.
Question 26. You have filed an application for patent. Claim 1 of the specification recites features A, B, C and D of the invention. Claim 2 is a dependent claim reciting a feature E. Examination report cites document D1 for anticipation, lack of novelty, and has identified A, B and D in D1. Which of the following is most likely to be your response to the examination report? Options A. Amend Claim 1 to add the feature E of Claim 2 into Claim 1 to render Claim 1 novel. B. Withdraw application as it is likely to be refused. C. Retain Claim 1 as such and point out to controller that D1 do not disclose feature E. D. Retain Claim 1 as such and point out to controller that D1 do not disclose all features of Claim 1.
The correct answer to question 26 is option D. Retain Claim 1 as such and point out to the controller that D1 does not disclose all features of Claim 1. Explanation. Since document D1 only discloses features A, B, and D, but not feature C, you could argue that Claim 1 is novel over the prior art cited in the examination report because it includes feature C which is not disclosed in document D1.
Question 27. Patent shall not be granted before the expiry of months from the date of publication of the application under Section 11A. Options A. 6 months, B. 8 months, C. 12 months, D. 9 months.
The correct answer to question 27 is option A. 6 months. Explanation. According to Section 11A of the Indian Patent Act, 1970, a patent shall not be granted before the expiry of 6 months from the date of publication of the application under Section 11A.
Question 28. A U.S. citizen is a patentee in India. His patent rights are valid in A. India, B. USA, C. India and USA, D. All of the above.
The correct answer to question 28 is option A. India. Explanation. If a U.S. citizen is a patentee in India, then their patent rights are valid only in India. Patent rights are territorial in nature and are only valid in the country where the patent has been granted. So, if the U.S. citizen has been granted a patent in India, then their patent rights are only valid in India and not in the USA or any other country.
Question 29. Meenakshi filed an application accompanied with a provisional specification. She filed a complete specification within 6 months. Claim 1 is partially disclosed in provisional application and partially disclosed in complete specification. The priority date of the claim shall be options A. Date of filing of the complete specification, B. Date of filing of provisional specification, C. Controller shall decide based on the disclosure of the specifications and the content of the claims. D. As the subject matter of claims is partially disclosed, the priority date will be considered as between the date of filing of provisional and complete specification.
The correct answer to question 29 is option A, the date of filing of the complete specification. Explanation. The priority date of a claim in a complete specification is determined by the earliest date on which the subject matter of the claim was disclosed in a specification filed in respect of the application. In this case, since Claim 1 is partially disclosed in the provisional specification and partially disclosed in the complete specification, the priority date of the claim shall be A, the date of filing of the complete specification.
Question 30. Nirmala, an Indian scientist working in NASA, files an international patent application (PCT) with basic application in USA on 30th January 2010. She plans to file national phase application in India. Which of the following is correct? A. She has to file national phase application within 31 months from the basic USA application filing date. B. She has to file national phase application within 48 months from the basic USA application filing date. C. She has to file national phase application within 12 months from the basic USA application filing date. D. None of the above.
The correct answer to question 30 is option A, 31 months from the basic USA application filing date. Explanation. Under the Patent Cooperation Treaty (PCT), an applicant has a time limit of 30 or 31 months, depending on the country, from the priority date to enter the national phase in each designated country. In India, the time limit for entering the national phase is 31 months from the priority date. So in this case, Nirmala would have to file her national phase application in India within A, 31 months from the basic USA application filing date. We hope you found this video helpful. If so, please share it with your friends or relevant groups preparing for the patent agent examination. Consider subscribing to our channel and clicking the bell icon for new video notifications, so you never miss out on our latest content and updates. We appreciate your feedback in the comments section and a thumbs up on this video. Your support inspires us to create more informative content. Check out our IPR and Patent Agent Examination Guidance playlist for more resources. Thank you for your support.